Now, when a court case prompts references to Magna Carta and causes Jacob Rees-Mogg, the leader of the House of Commons, to defend the jury system as a great, sublime protector of liberties, you know something's up. Then, when a former Justice Secretary, Sir Robert Buckland, calls the verdict of the jury in that case perverse and adds, and I quote, "I don't think we want to see our Crown courts becoming political playgrounds. They're not places for politics, they're places for the law to be applied and for the evidence to be assessed." Well, you know, whatever it is that's up is pretty significant. I speak, of course, of the acquittal by jury of the Colston Four, who were charged with causing criminal damage to the statue of Bristol slave trader Edward Colston last year by pulling it down, dragging it to the water's edge and then chucking it in the river. They admitted that they had done it, but they insisted they were innocent of any wrongdoing. The jury agreed, and that is an end to the matter. Or is it? We now know that one of the government's top law officers, the Attorney General Suella Braverman MP, is carefully considering whether to refer the case to the Court of Appeal. Now, she acknowledges that she can't overturn the jury's verdict, but says it demands clarification on precedent and legal arguments. For that, she stands accused by Labour's Emily Thornberry of playing politics with the case. Tory MPs, in turn, accuse Ms Thornberry of taking sides. And finally, a former Supreme Court Justice, Lord Sumption, here in today's Telegraph, suggests that the jury verdict ran counter to the evidence. He rejects the defence of the Colston Four that for them it was a matter of conscience to remove a statue celebrating an evil man, which was in itself an infringement of their human rights. Now, to be crystal clear, a jury has acquitted the four, found them innocent of all charges. No ifs, no buts. And a jury verdict does not set a precedent in law. But the case itself does raise a number of fascinating questions. First, their defence. The Colston Four argued that the presence of the statue was a hate crime against Bristol's residents and that it was effectively theirs to destroy because they lived there. Their barristers argued that their actions had been justified because the statue was a hate crime to the people of Bristol because of Colston's links to the slave trade. Now, the jury had to decide if the defendants honestly believed that a crime was being committed by the presence of that statue. Crucially, not whether a crime had been committed, but whether the defendants honestly believed that a crime was being committed. What's more, they had to determine if the defendants' actions amounted to the use of reasonable force in removing the offending statue. Well, they did. Their lawyers also used the same argument as Extinction Rebellion activists who recently argued, successfully, that their conviction for blocking a road was a disproportionate infringement of their human rights, rights that are enshrined under Articles 10 and 11 of the European Convention on Human Rights. The jury accepted that too. Now, unlike the United States, we don't know how the jury came to those conclusions, and we cannot ask them. Their rights and their privacy are sacrosanct. Under Magna Carta, we are entitled to trial by our peers, and those peers don't have to justify a single thing that they decide. That is part of their role as the great, sublime protector of our liberties that Jacob Rees-Mogg referred to. But we can ask what the significance of the verdict is. Now, I was one of those who said on social media that it surprised me, and I thought it risked setting a precedent for what I described as other malcontents. I was promptly put right by a number of barristers. There is no precedent set at this stage. It was also pointed out to me in no uncertain terms that the fact that the four tore down the statue on camera and dragged it and ditched it on camera was irrelevant. It was all about their motives, their human rights, and what the good people of Bristol thought about it too. It may be that that is why the four chose, under advice, to opt for a jury trial rather than a magistrate's hearing. They felt that they'd acted on behalf of the long-aggrieved people of Bristol from whom the jury would be drawn. So the very presence of a statue of a slave trader is deemed offensive, entitling folk to get rid of it, to avoid further offence. The act of pulling it down and chucking it in the harbour is justifiable under the Four's human rights, not to be offended by said state. Food for thought, we thought.